This is an IEPA Tariff Refund Recovery Public Information Campaign by Tariff Recovery Group USA. Visit tariffrecoverygroupusa.com for additional information about claiming your tariff refund or to apply for a cash advance on a claim that you have already filed. If you run a business that imports goods into the United States, your phone has probably been ringing off the hook with cold calls from people you have never heard of, all trying to talk to you about tariff refunds that your business may be owed by the government. While your LinkedIn DMs and email inbox is probably full of messages from those same people and companies, all wanting to recover your tariff refund, all of them telling you it's urgent, and all of them asking for your trust in them to file and recover your refund for you. This is happening to hundreds of thousands of importers right now, but before you respond to any of their many calls, DMs, or emails, there are a few very important things you need to first understand that could protect you from having your tariff refund claim being completely nullified, which can easily happen with recovery agents that don't know what they're doing. A common problem that we are seeing right now is that many U.S. importers are relying on inexperienced brokers or law firms with limited experience in customs and trade law, only to see their refund claims being completely and irreversibly sunk. Unfortunately, this can happen because of something that most recovery agents aren't telling you: a hidden risk sitting beneath the surface like an iceberg. The big problem is that you simply won't see it coming until your claim has already been struck, and by then it's too late to reverse course. These threats need to be avoided before your claim is filed, during the assessment period. Finding out about them only after your claim is filed will be too late to do anything about it. It's time to add full transparency to this whole process, to better equip you to deal with the recovery agents that would prefer for it to remain seemingly opaque and complex. In the short time that it takes to watch this presentation, you will know more about the risks involved with incorrectly filing for your tariff refund than most of the people who have been calling you. Not only that, but you will also know what to do about it and how to prevent putting your own tariff refund claim at risk. Here's what we're going to cover in this video: why the CPB's CAPE portal can only be used to file for some of your refund, not all of it, and why the number of refunds CAPE can actually process is shrinking every single day. Why some recovery agents may be using your refund claim as their training ground, and the one filing mistake that can permanently forfeit a large claim with no way to undo it. 3 specific things your customs broker is not legally allowed to do for you, no matter how good they are, which could end up costing you most, if not all, of your refund. A quick 4-question test that exposes them, in less than 30 seconds, to instantly know whether or not the person cold calling you can potentially secure your full refund. And how much interest you may already be forfeiting every day that your claim goes unfiled. So why is everyone suddenly calling you about a tariff refund? What are most of them not telling you? And what do you actually need to know before responding to any of them? In February 2026, the U.S. Supreme Court ruled the IEEPA tariffs unconstitutional, but this ruling only came after the government had already collected approximately $166 billion in tariffs from more than 330,000 U.S. importers across 53 million customs entries. And as per the Supreme Court order, that money is being refunded right now, but only to businesses that file claim. But your claim could also mean big money for unscrupulous recovery agents. As soon as the Supreme Court's tariff refund judgment was passed down, an already active market of import brokers, law firms, and recovery agents all ramped up their outreach. The ruling also created an overnight industry of new players suddenly branding themselves as tariff recovery services, many of them appearing seemingly overnight, all feverishly trying to be the first to cash in on your refund in exchange for large upfront and back-end fees, which they are hoping that they can get you to pay even if you don't get your refund. The CBP itself issued an official warning in May 2026 about the sudden increased volume of unsolicited outreach. They specifically flagged scammers using mass email, phone calls, and social media campaigns to target U.S. importers, and their advice is direct: to treat any external website or unknown party offering to process your refund with extreme caution. The CBP's warning makes the point that it isn't simply a case of most of it being a scam, nor is most of it all fine and above board. The truth is that most of the sudden tariff recovery outreach that we're seeing sits in the murky middle, a legally gray area that is difficult for most businesses to navigate on such short notice. And this is actually the hardest problem, because the gray area is exactly where the bad actors can most easily hide, hoping that you are too confused by the complexity of the issue to know for sure that you can't trust them. Not only that, but an additional problem is that while many recovery agents are legitimate, they are also limited in what they can actually do to secure the full extent of the refund that you may be owed. This is because they can file through CBP's CAPE portal for straightforward entries, but they cannot handle the roughly 37% of entries that require court litigation, nor can they protect your import entry history from review under attorney-client privilege. This may not sound like a big deal, but it potentially could be, and you wouldn't know until it is too late. And by then, the government has been given free rein to look into all your imports. Here's the part that matters. Your refund is at stake here, not theirs. It is not in their best interest to fully inform you of everything that could go wrong if you file your claim through the wrong recovery agent. This predatory behavior is often concealed by creating a sense of urgency. Act now! Limited time! Sign today! When the real reason for the rush is to get you to commit before you've had time to ask the questions that would expose the gaps in what they can actually do to guarantee the securement of your tariff refund in full. The uncomfortable truth is that with an inexperienced recovery agent, your claim can become their learning curve if they do not have years of experience in U.S. customs and trade law. If they make mistakes, you end up absorbing the consequences. This could mean simply not receiving the full potential of your refund, which often requires an attorney to fight for in court, depending on the complexity of your claim. And in the worst-case scenario, it could mean your claim being denied with no recourse or allowance to file again. And all this can be made even worse if you have paid any non-refundable upfront fees to the recovery agent. Because tariff refund claims are a one-shot affair, which cannot be refiled if done wrong, you never want to be in a position where a recovery agent is using your claim as a guinea pig. If they're learning about the process on the fly, it could cost you a great deal, but not them. None of this is hypothetical, nor is it meant to needlessly scare you. Remember that we've seen this exact same pattern play out before. The Employee Retention Tax Credit went through the identical dynamic a few years ago when a large government refund pool, an overnight industry of recovery promoters, and a wave of businesses that moved fast with the wrong provider and ended up with rejected claims, IRS scrutiny, or money simply left on the table. Many of those promoters are now under IRS investigation. IEPA refunds involve significantly more money than ERTC ever did, and more money always means more blood in the water, so to speak, and more bad actors. The pattern is repeating itself, but on a bigger scale. Some of those calls might have come from the customs broker you've already been working with for years. A half-decent broker probably can file a CAPE declaration on your behalf. For straightforward entries, they have the technical ability to do this, and for some importers, that may be entirely adequate. But there are three crucial things that a broker cannot do. Firstly, brokers cannot file litigation at the Court of International Trade. Over 37% of IEPA-affected entries are finally liquidated, which means that the protest window has closed, and CAPE simply cannot process them. The only path left for refund claims on those entries is litigation, and that requires a licensed customs attorney admitted to the CIT. Brokers, even good ones, are not attorneys, and therefore cannot take this legal action on your behalf. Secondly, brokers cannot protect your entry history review under attorney-client privilege. If a broker goes through your past entries and finds something misclassified, such as goods filed under the wrong tariff code, which is more common than most importers realize, that conversation is legally discoverable, meaning that a CBP audit can access it. But the same review, if done by a customs and trade attorney, is privileged and therefore legally protected. This distinction matters enormously if your import entry history has any sort of complexity. And finally, brokers cannot evaluate your class action exposure. There's an active wave of litigation targeting companies that passed import tariff costs on to their customers and are now also claiming a refund. A broker has no way to assess that risk for you, but an attorney can, and they can do it under privilege, meaning that you are legally protected from day one. None of this means that you should not file your tariff refund claim through your trusted import broker. You just need to understand the legal limits of their ability and authority, and to understand when you may need more legal protection, capability, and experience in dealing with U.S. customs and trade law. And you need to know all of this before you file your claim. This is nothing against import brokers, but you need to first be aware of these facts. Just to recap what a good import broker can do, what they cannot do for you, and what you may need a customs and trade attorney to do in order to help secure your full tariff refund. Customs brokers can file CAPE declarations, while only a registered attorney can file CIT litigation. Protect your import entry history under attorney-client privilege, and protect your business from class action assessment. Here's the one thing almost nobody is likely explaining properly. There isn't one way to get your refund. There are three. And which one applies to your business depends on the status of each individual shipment you've made, not your business as a whole. Most of the people contacting you only know about one of the three. That's not necessarily dishonest, just incomplete. And incomplete information on something this size is its own kind of risk. The first pathway is CAPE, which only applies in a specific window, from the moment an entry is unliquidated up to 80 days after it liquidates. It's fast, it's portal-based, and right now it covers only about 63% of all IEPA-affected entries, and that number is decreasing daily. If a broker is offering to help you, this is almost certainly the only pathway they mean. The big limitation with the CAPE portal is that when you file your CAPE declaration, it is a one-shot deal. If your filing is accepted by CPB, then your refund is processed. But if it's rejected for whatever reason, for something as small as a formatting error or a missing bank detail, there is no revision process. You don't get to fix it and resubmit it through CAPE again. For most error types, that entry's refund is simply and permanently forfeited. The second pathway is a formal protest filed directly with CBP. Once the CAPE portal window closes, you have up to 180 days after liquidation to go this route. It is slower, as CBP has no deadline to process protests, so this can take a year or more. Many importers will end up here filing protests simply because nobody engaged them early enough to use CAPE. The third pathway is litigation through the Court of International Trade. This is the only path left once the 180-day deadline has passed. This litigation cannot be undertaken by an import broker, and it cannot be filed through a portal. It can only be done through a licensed attorney admitted to the CIT, and only within 2 years of liquidation, which is why 2026 is a crucial watershed year for tariff refund claims, as time runs out on all three pathways. CBP has confirmed a real timeline. A second wave of processing covering reconciliation entries launched on June 29th. A third wave, covering finally liquidated entries, is targeted for late July. But that third wave only applies to importers who've already filed suit at the CIT. In other words, filing the lawsuit isn't just your only option if you miss the deadline. For many importing businesses, it's about to become the key that unlocks the whole process. So while there are three pathways to filing your tariff refund claim, the crucial 180-day deadline is a real, hard cutoff. Once those 180 days pass, for most entries, the only way left is litigation. Knowing which path to take for every single import shipment on your books is the entire game, and the more complex it gets, the more you may need a registered attorney. What makes all of this difficult to manage is that every single import entry has its own clock, running independently. A shipment that arrived in March 2025 is on a completely different liquidation timeline than one that arrived in October. If nobody is tracking that, entry by entry, deadlines pass silently, and nothing announces that they've passed. There is also a cost to waiting, aside from simply not getting the refund that you're owed, that most importers don't think about. Interest only accrues on claims that have been filed. Statutory interest on these refunds runs at roughly 6 to 7%, compounding from the date you originally paid the tariff. If your claim isn't filed yet, you're not simply waiting in line, you're forfeiting interest you're legally entitled to, every single day that it sits unfiled. Here's a practical 4-question test that you can use right now on anyone who has already contacted you or the next person that calls asking to file your tariff refund claim for you. Can you file litigation at the CIT for finally liquidated import entries or only through CAPE? If the answer is CAPE only, they cannot recover the 37% of entries that need court action. Will my entry history be protected from government review by attorney-client privilege? If the answer is no, you're taking on real compliance risk every time they look at your data. What happens if my CAPE declaration has an error? Can we refile, or is that entry gone? A competent operator will be upfront, but one that isn't will tell you not to worry about it. Are you a licensed customs and trade attorney, admitted to the Court of International Trade? This is a very important and relevant legal credential when dealing with CPB, but without it, tariff refund recovery agents cannot do the full scope of what most complex claims require. Let's bring this all together now in a very quick recap. There isn't just one refund process, there are three. Most of the recovery agents contacting you only know about CAPE, which is the fastest, but also the most limited option. The deadlines on each of the refund recovery pathways all run independently of each other, per entry, whether or not anyone is actually watching them. And the person or company offering to help you may be completely well-intentioned, but still only capable of recovering a fraction of what you're actually owed. That's not a reason to panic. It's a reason to get one proper, complete assessment of your entire import history every entry, every pathway, every deadline before you commit. If you imported goods subject to IEEPA tariffs between February 2025 and February 2026, you likely have a legitimate claim. Filing windows are closing. The first step is independent assessment of your complete import history, not just the entries that happen to be easiest to process, so you can know now if an attorney is needed to recover your full tariff refund. This has been part of an IEEPA Tariff Refund Recovery Public Information Campaign. For all the up-to-date information about how to collect your refund of unconstitutionally collected IEEPA tariffs and to check if your business qualifies, visit tariffrecoverygroupusa.com, where you can file your valid refund claim today with the full backing of an independent, nationally ranked U.S. Customs and Trade law firm. There is no upfront cost to file your claim, and if you have already filed, regardless of how the filing was done, we offer a way to get a cash advance on your refund within just 5-10 business days, not by waiting months or years. Check your eligibility for free and without obligation today at tariffrecoverygroupusa.com. It costs nothing and takes only a few minutes. Link in the description and pinned comment.